At the International War Crimes Division of High Court in Kampala, the former Guantanamo Bay detainee was facing 3 charges: soliciting support for terrorist organization, Allied Democratic Forces ADF, rendering support to terrorist organization, and belonging or professing to belong to ADF. Of the 3 charges, Judge Susan Okalan found Jamal Chiemba guilty of 1 count of soliciting support for terrorist organization, Allied Democratic Forces ADF.
I have carefully scrutinized the record of proceedings. I know that at one point, PW2 stated that the accused told the police officers that he was a supporter of the ADF. However, on a holistic review of PW2's entire testimony, I'm not persuaded that this isolated statement materially undermines the overall reliability and credibility of his evidence. From the outset, on both his examination in chief and cross-examination, PW2 was consistent in stating that after hearing the accused's remarks, he initially sought the assistance of a nearby police officer but was unsuccessful. This prompted him to approach PW5, a military officer attached to KCCA office in the back. At this point, his evidence, apart from the impugned statement, thus at no point in his evidence, apart from the impugned statement, that he told the police in court, does PW2 suggest that the accused was ever in police custody or any police officer played a role in this arrest. It is clear that the statement in question arose in the context of PW2 responding to questions about a written statement he had previously given to police. In such circumstances, it is plausible that PW2 either misspoke or made an advertent slip of the tongue, especially given the stress and the complexity of testifying about events that unfold rapidly and involve multiple state actors and some time ago. In assessing credibility, courts are mindful that minor inconsistencies or isolated slips do not necessarily render a witness unreliable, particularly when the bulk of the evidence is internally consistent, corroborated by other testimony, and consistent with overall sequence of events. I'm therefore satisfied that, notwithstanding this singular witness, PW2's testimony remains credible and reliable for purposes of determining the facts of the issue. The defense also raised contentions regarding the testimony of PW5, arguing that he gave oral evidence on matters not contained in his police statement. The matters complained of concerned the alleged utterances made by the accused while in the custody of PW5 and PW7. Having disregarded that evidence above, I find no purpose in responding to the defense's contention because I have not accepted the evidence of PW5 and PW7 regarding the utterances of the accused in their presence. The accused denied making the statements attributed to him, suggesting possible bias due to his arrests and previous arrests by security authorities for terrorism-related incidents. He argued that these prior arrests might have influenced the perceptions of those involved in this case. However, the prosecution's evidence, especially PW2's, whom I consider the main witness, implicates or indicates otherwise. PW2 clearly testified that he neither knew the accused nor had any contact with him before the events on that day of 29th January. His first interaction with the accused was solely based on witnessing and hearing statements that formed the basis of this. After observing his conduct, he immediately informed PW5, resulting in the arrest of him. Moreover, the record shows that during the ensuing process, the accused voluntarily disclosed his name, occupation, residence to both PW2 and PW3, thereby confirming that neither witness had prior knowledge of his identity. His account is further corroborated by the accused's own testimony, in which he describes how, upon arrival at Fire Brigade headquarters, an army officer, most likely PW7, recorded his personal details and informed him that he would be taken to his superiors for further discussion. Such actions are consistent only with the scenario in which authorities were encountering the accused for the first time and needed to establish his identity. Had there been any prior acquaintance, such formal identification measures would not have been necessary. I find PW's evidence reliable, internally consistent, and unshaken at cross-examination. The witness was clearly unequivocal when he stated that he had the accused under the tuned words, prompting him to take immediate action by notifying PW. In my assessment, PW5 responded as a reasonable and responsible army officer, taking the information seriously and acting swiftly upon receiving PW2's report. He mobilized a contingent of 10 to 12 armed officers to effect the arrest of the accused, whom he reasonably perceived as a possible threat. The sequence of these events, together with the absence of any prior relationship between the witness and the accused, strongly supports the credibility of the prosecution's narrative through PW2 and PW5 regarding how the accused was arrested. It further diminishes the plausibility of the accused's suggestion of bias or fabrication. Therefore, I find the prosecution has convincingly proven that the accused solicited support for a terrorist organization, specifically the ADF. I now turn to the defense of insanity.
Court based its ruling on the prosecution presented witness from the 8 witnesses. That prosecution used to prove all the ingredients in this case. Judge Susan Yokalanyi, however, acquitted Jamal Chiyemba of the charge of rendering support and belonging or professing to belong to the terrorist organization. The court ruled that prosecution failed to prove those offenses beyond reasonable doubt.
1 is dismissed in favor of the accused. B, the accused is found not guilty on count 2. 3, the accused is found guilty on count 3, namely soliciting or inviting support for a terrorist organization. And so on.
It further held that the relevant legal provisions laid up by the prosecution was inapplicable to the facts of the case. Jamal Chiyemba was arrested on 29th January 2022 at Old Kampala Tax Park in Kampala after allegedly standing in a public place and shouting, "Long live ADF, long live ADF, ADF we wangale," and declaring that if civilians do not support ADF and if the government did not engage the group in dialogue, there would be bloodshed in the city. During the trial, Jamal Chiyemba raised the insanity's defense, claiming to suffer from bipolar. However, the court rejected the defense after finding that the evidence demonstrated that he was capable of making rational judgments and undertook the nature and consequences and actions at the time of the offense.
The alleged uttering of the words attributed to him, he was incapable of understanding that his actions were wrong and as such was not responsible for them. The defense of insanity is provided for under Section 11 of the Penal Code. Cap 1. The person is not criminally responsible for an act of omission. At the time of doing the act of omission, he or she is, through any disease affecting his mind or her mind, incapable of understanding what he or she is doing, or of knowing that he or she ought not do the act or make the omission. But a person may be criminally liable for an act of omission, although his or her mind is affected by disease, if that disease does not in fact produce upon his or her mind one or other effects mentioned in this section in reference to that act of omission. Section 9 of the Penal Code provides that every person is presumed to be of sound mind and to have been of sound mind at the time in question until the contrary is proven. By virtue of that section, it's tried law that the burden of proof lies on the accused person who is seeking to rely on this defense. The Court of Appeal in Jumba, Joshua versus Uganda, held that the standard of proof is on the balance of probabilities. The accused person must therefore show on all the evidence that insanity is more likely than sanity. In Bateganda, Bagatenda Peter versus Uganda, the Supreme Court held the essence of the defense of insanity is that the accused did not know what he was doing. Or if he knew, he did not know that it was wrong. This is the gist of the McNaughton rules, which have been adapted and applied in our courts of Uganda. The court also found that the accused person's state of mind may be discerned from the evidence on record, even whether from the prosecution side or the statement made by the accused person to the police. In determining whether the accused's defense of insanity is sustainable, two key questions must be asked. First, whether at the time of the alleged offense, the accused was suffering from a disease affecting his mind. And second, whether that disease rendered him incapable of understanding the nature of his actions, and all knowing that he ought not to have committed the acts. Regarding the first question, the evidence is unequivocal. It is common ground that the accused had been diagnosed with bipolar affective disorder as early as 2016. PW6, a psychiatrist described this condition as chronic, incurable mental illness affecting the mind. He explained that treatment primarily involves medication to stabilize the patient, and that discontinuation of medication leads to a high risk of lapse. It was further established that the accused's condition was ongoing at the time of the offense in 2022 January. On the basis of this uncontroverted medical evidence, I'm satisfied that the accused was suffering from a disease affecting the mind when the offense was alleged. Turning to the second question, whether the disease rendered the accused incapable of determining his actions or distinguishing right from wrong, the accused's testimony is instructive. He stated that prior to his arrest, he had ceased taking his prescribed medications due to adverse effects, and that on the day of his arrest, he was traveling to Bukini in fear that his relatives would compel him to undergo mandatory treatment. He described the impact of his illness, particularly during manic episodes. He would experience mood swings, become angry, impatient, aggressive in response to irritation, and excessively elated and hyperact in response to pleasurable stimuli. He also described an inability to sustain attention or concentrate on any particular task. This account was corroborated by PW6, an experienced psychiatrist, who testified that manic episodes in bipolar affective disorder can cause an individual to exhibit relevant, elevated, and expansive mood, impaired concentration and attention, and deficits in abstract reasoning, judgment, and orientation in time, place, and person. PW6 clarified that while the testimony and the general knowledge may be preserved, PW6 clarified that while memory and general knowledge may be preserved, they tend to be disorganized or free-flowing during such procedures. Under cross-examination, he reiterated that a person in a manic state has diminished understanding and may lack appreciation of their surroundings and of the implications of their conduct, leading to reduced ability to understand the nature or wrongfulness of their actions. The evidence before the court establishes that the accused suffers bipolar disorder disease affecting the mind in certain circumstances which may in certain circumstances impair somebody's ability to understand what he's doing, or to appreciate the consequences of his wrongful acts, as contemplated by Section 11 of the Penal Code. This evidence also demonstrates that a person with this condition may experience lucid periods when the evidence, when appreciated, when appropriately medicated, fully possesses his faculties, mental faculties. Having found that the accused suffers from disease of mind, the next question is for me to find if this disease of the mind affected him at the time he committed the offense. The accused describes the event of the day of his arrest in the following terms. I realized that my relatives wanted to re-inject me. I decided to run away. I went to Bugiri where I had a friend I met in prison. I decided to buy him fruits from a window market. I was thinking of getting a solution to the conflict that led to my constant detention and mental illness. That was on 29th January 2020. As I was walking from a window market towards the old taxi center, I saw a UPDF soldier in uniform. He was wearing a red cape and holding a gun. In my mind, I thought the best way to hold I thought that the best way to hold these dogs, or I thought that to be the best way to hold these dogs. I approached the army man, whom I believe was Fred Haru, one of the prosecution witnesses. My intention was that he may lead me to his superiors to have peace talks to end the conflict that was leading to my arrest between the government of Uganda and the UP. He ignored me. He continued to the taxi park. After boarding the taxi, he came with a group of other soldiers and asked me to disembark, which I did. Having considered the totality of the evidence, I find the accused's conduct on the material bill demonstrates several indicators of awareness, logical reasoning, and an appreciation of both his circumstances and his actions. By his own account, the accused made a conscious and deliberate decision to flee from his relatives in Namasuba to Ujiri, motivated by a desire to avoid medical intervention. Specifically, being re-injected with a drug. This choice reflects not only situational awareness, but also the ability to weigh options and to take purposeful action in response to perceived threats to his personal autonomy. Moreover, the accused's decision to bring fruit, rather to buy fruit, to a sick friend or for a sick friend, rather than visit him empty-handed, further illustrates a capacity for empathy, anticipation of social expectations, and planning. This gesture suggests that he was able to consider the needs and the feelings of others and act according to behavior consistent with a degree of social situational awareness. Additionally, the accused's account of his interaction with the UPDF soldier demonstrates complex reasoning. He described recognizing the soldier as a member of the security forces and deciding to approach him as a possible intermediary in the ongoing conflict with the ADF and the UPDF. The accused articulated a motive to hold peace talks and expressed hope that engaging the military could lead to a solution of a broader conflict, which he regarded as the root cause of difficulties and repeated detention. This reflects not only an understanding of his environment and the roles of those within it, but also the ability to form abstract goals and pursue them through intentional action. Even if I have previously found aspects of his account regarding his interaction with PW5 not credible, the mere capacity to construct such a narrative indicates the presence of cognitive faculties such as memory, reasoning, judgment. Indeed, the accused's belief that acting as a mediator would prevent his future arrest shows that he was capable of making mental assessments, forming intentions, and drawing causal inferences in his situation. Causal, but not casual. Causal. Taken together, These elements of the accused's conduct and thinking on the day in question suggests, despite his mental illness, he retained a considerable degree of awareness, understanding, and volition. These observations are relevant in assessing whether, at the material time, his conduct reached a level that would render him incapable of appreciating the nature or the wrongfulness of his actions, in accordance with the legal test of insanity. The accused never denied being the whole taxi park on the material day about 9 years. PW2 and PW5 testified that he introduced himself by name and stated that he was an imam from Namasura. If anything, the accused's account of events following his apprehension by PW2 largely aligned with the testimony of PW2, namely that upon his arrest in the old taxi park or at the park, he was taken to KCCA offices where he was searched, thereafter to Fire Brigade's headquarters, with the expectation that he would meet PW5 superiors. He further stated that while at Fire Brigade headquarters, his particulars, including his name, occupation, residence, were recorded, and that the officer who was most likely PW7 informed him that he would be taken to superiors. Afterwards, an armored vehicle arrived and conveyed him to Kireka Barracks. In cross-examination, the accused stated that he would neither remember nor ascertain whether he uttered the words of soliciting support for the ABA. Whereas the burden of proof is not on him, I find it highly likely that the accused is feigning forgetfulness selectively, as he was able to recount all the details of the events before, during, and after his arrest, save for the utterances complained of. All the evidence indicates that at the time of the alleged offense, the accused's mental state was not impaired, as defined by Section 11 of the Penal Code Act. He demonstrated clear understanding of time, place, and persons involved. He recognized his actions and was aware of potential consequences. Therefore, the insanity defense is unsubstantiated, and the accused does not discharge the burden of proof on the balance of probabilities. As a result, I make the following findings.
Jamal Chiemba, who has been on remand throughout the trial, was further remanded to Luzira Government Prison until 31st July 2026, when court is expected to deliver its sentence. Under the law, the offence of soliciting support for a terrorist organization carries a maximum penalty of 10 years imprisonment or a fine of 10 million or both. Meanwhile, court assessors in Susan Magara case have advised Judge Alex Ajij to convict the 9 suspects after concluding that the prosecution has proved all the ingredients. Regarding offences levelled against the accused,
Joint assessor's opinion in the matter of Uganda versus Lubega Yusuf and 8 others.
Ndowooza eno bagikoledde wamu mu musango guno oguliko Uganda ng'ewaabira Lubega Yusuf wamu ne banne.
Many of the accused persons are indicted with the offences of kidnap with intent to procure a ransom and murder.
Nti mwe muvunaanibwa omusango ogw'okuwamba ng'era mulina ekigendererwa eky'okuba nga mufuna essente nnyingi wamu n'okutta.
My lord, the accused persons pleaded not guilty
nti era temwakkiriza musango guno
to the charges against them,
nti era ogwali gubavunaanibwa,
and the prosecution bears the burden to prove both offences beyond reasonable doubt.
Nti era abawala ba gavumenti balina omugugu ogw'okugenda mu maaso okuba nga bakakasa kkooti ddala guno omusango mwaguza nga tebalekamu bumulungufu.
My lord, the ingredients of the offence of kidnap with intent to procure a ransom are
nti omusango oba emisango egy'okuba nga muwamba oba okuwamba omuntu n'ekigendererwa okuba nga mufuna ssente oba nga mufuna ssente nnyingi biguli nti
number 1, that the deceased was taken or detained unlawfully.
Nti ekisooka nti omuntu oyo yawambibwa n'atwalibwa nga teyeesiimidde.
Number 2, that the taking or detention was by use of force, or fraud, or coercion.
Nti omuntu oyo yatwalibwa n'aterekebwa nga waliwo okukozesa eryanyi mu kumuwamba.
And number 3 is that the taking or detention was done with a specific intent to procure a ransom.
Era okumuwamba okuno okumutereka kwalina ekigendererwa ekyokubanga waliwo sente ezifunibwa ennyingi.
Then lastly, number 4, that the accused persons participated in the commission of the act.
Ekisembayo nti mwe abantu abawaba bamina okubanga bamwakola ekintu ekyo.
My lord, the ingredients of the offense of murder include
ebikwata ku musango gw'okutta biri nti
number 1, the death of a human being occurred.
Ekisooka nti omuntu yafa.
And number 2, that death was unlawful.
Ekyokubiri nti omuntu oyo yattibwa mu bumenyi bw'amateeka.
Number 3, the unlawful act was done by malice aforethought.
Nti okutta omuntu oyo kwakolebwa mu bugenderevu.
Then number 4, that it was the accused persons who caused the unlawful death.
Era abantu abawaba balina okuba nga bakola ekintu ekyo ky'okutta omuntu mu bugenderevu.
My lord, the first, second and third ingredients of each offense are not in dispute as they were proved by all prosecution witnesses.
Nti ebintu bino byonna abawaba ba gavumenti babikakasa kkooti. Ekisooka ekyokubiri n'ekyokusatu babikakasa kkooti kubanga tebyaliko kutankanibwa.
Therefore, my lord, these ingredients were proved beyond reasonable doubt by the prosecution.
Kitegeeza nti aba gavumenti baakutiza kkooti nti ebintu ebyo byabaawo.
My lord, we shall dwell on the fourth ingredients of both offences, which is participation of the accused persons.
Tugenda kwesigama ku kawaayira k'okuna mu misango gino ebiri akalaga nti mwe mwenyingira mu kukola ekintu kino oba emisango gino.
And we shall study the participation of accused persons in offence of kidnap with intent to procure a ransom.
Njera tugenda kutandika n'akatundu ako akagamba nti omuntu yawambibwa nga waliwo ekigendererwa ekyokuba nga esente nnyingi zifunibwa.
My lord, PW 7 told this honorable court that she knew F5, but she didn't know his name. She didn't know his name, that she saw him when she was delivering a ransom near the parents.
Omuwala ow'omusanvu ayitibwa Kato Hassan Miro yagamba kkooti eno nti yali amanyi omuwaabi ow'okuna. Phone number 5.
I repeat. My lord, PW 7 told this honorable court that she knew F5, but she didn't know what his name. She didn't know his name. That she saw him when he was delivering a ransom near Deje.
Obujulizi eyajja mu kkooti namba 7 yagamba kkooti eno nti yali amanyi omuwaabirwa ow'okutaano ayitibwa Kyewolya Abubeka nti naye yamumanya bwe yali nga aleeta ssente okuba nga azimuwa mu kitundu ekyo kyogeddwa.
Near Deje Parents School on Busaabala Road.
Okumpi n'Endejje essomero eriyitibwa Parents School e Busaabala bwe yali azeeta okuziteekaawo mu kifo ekyo bwe yamulabya yali tamumanyi okuleeta ssente ezo.
Her testimony corroborated with the evidence of PW9, who clearly told this honorable court that he saw F5 leaning on a container while talking on phone. Then a lady came from Ondeje Parents School and kept on walking while carrying a laptop bag on her back, and it was black in color.
Nti obujulizi bw'oyo omujulizi namba 7 bwakwatagana n'obwobujulizi namba 9 yagamba kkooti nti yalaba omuwaabiro ow'okutaano nga yeesigamye ekikonteyina mu kifo ekyo ekyaleetebwamu ssente.
While talking on phone,
ng'ayogerera ku ssimu.
Then a lady came from Ondeje Parents School.
Nti omukyala yava ku ssomero lya Ondeje Parents School.
And she kept on walking.
N'agenda mu maaso ng'atambula.
While carrying a laptop bag.
Ng'akutte ensawo y'akakompyuta akatono.
On her back.
Mu nsawo ye.
and it was black in color. When she reached, she put down the bag and the phone she was talking on. She also put it on the bag by the roadside. After she returned and started walking back, then she bypassed with F5. They were like 15 meters from where she put the bag. F5 was putting on a jumper with a hood, but his face was clearly seen with a beard. Then he picked the bag and the phone and continued walking towards Ndejezanta. When they saw him, they were surprised because they didn't know him in the area. Then one of his friends, Chintu, shouted at him asking where he was taking the woman's bag. And he replied that they were together and that she was coming. My Lord, PW9 statement corroborates with PW7.
Who stated
that a man called her and instructed her to take the ransom to Busabala near Chibiri Primary School.
Chibiri Primary School.
And that as she was going back, she saw a man taking the opposite direction who looked like the late Mose Radio. My Lord, we have relied on the evidence of PW10. Who told this honorable court that on the 7th of February 2018, at around 9:15 p.m., he received information from PW2 that PW1 had been speaking to Susan Magara on phone when he suddenly heard screams and distress before the communication was abruptly terminated. Upon receiving this information, PW10 immediately initiated tracing measures on the phone numbers used by the deceased. In line, MTN 0774 63 46 96 belonging to Susan Magara was traced to Lunguja, while the Airtel line 0701 63 46 96, which she had used during her communication with the PW1, had already gone off. This corroborates with the evidence of PW1. He arrived at PW4's home. To the victim. When he reached, they handed over 2 phones, a Nokia and Techno phones, and he took their photographs. After that, the bodyguard of Mr. Magara gave him a parcel in a Kavera. He found a box of ketamine, ketamine 50 injection. Ketamine 50 injection. I beg your pardon. He found a box of ketamine 50 injection. The word 50 injection was written on ketamine.
Okay. Box kaliko ekigambo ketamine with a written word, a must watch. Inside the box, there was a piece of catch envelope with the 2 cut off fingers, the index and big finger, with Q-tex on them. In the same box, there was a folded ruled piece of paper which had a 1 GB SD card. Flash or SD card.
All those exhibits were recovered. He photographed, labeled and submitted in different laboratories for examination. The cut-off fingers were submitted to Government Analytical Laboratory in Wandegea. The 2 phones, piece of a folded roll of paper, was submitted in the forensic laboratory. The SD card was submitted to the Cyber Crimes Intelligence Department. SD card Forensic Laboratory Department. Cyber Crime Department. For analysis, which were received by PW14. PW15 testified that he was part of the team that went to Usafimosi to effect an arrest where 35 male adults and 120 children between 3 to 17 years.
Wamu n'abaana 12 abali wakati w'emyaka 3 ku 17.
The number of women or ladies was not mentioned.
Nteza ennamba y'abakyala teyayogerwako.
These were all arrested, and in the process,
bonna baakwatibwa era mu kugenda maaso n'okubakwata.
it's where PW11's arm was chopped off.
Nti awo omujulizi ow'11 omukono gwe gwasalibwako.
This corroborated with the evidence of PW16.
Buno obujulizi bwagenda mu maaso ne bukwatagana n'obujulizi obw'omujulizi ow'16.
PW17 testified in this honorable court that
omujulizi ow'17 yagamba kooti nti
she knew one of the accused persons, A4,
nti yali amanyi omu ku bawalabirwa obuvunaanyizibwa ennaku z'omwezi 28 ogwokuna 2018
from his commander, Sergeant Wanyama Richard,
okuva eri mukama we Sergeant Wanyama Richard,
who told him that there was an operation to arrest a lady
nti waliwo ekikwekweto ekyokukwata omukyala
who was alleged to be one of the people
eyali agambibwa okuba omu ku abo
who kidnapped Susan Magara.
abakwata omugenzi Susan Magara.
And so they proceeded to Entebbe Road, Najanankumbi,
Era bagenda mu kifo ky'Entebbe Road mu kifo kye bayita Najanankumbi
at Shell Cars,
ku ssundiro ly'amafere baliyita Shell Cars,
where A4 was arrested from.
era omukyala Nakanji we bamukwatira.
My Lord, we have also considered the evidence of PW21.
Era tugenze mu maaso ne tutunula n'obujulizi obw'omujulizi ow'21
Who told this honorable court that
eyagamba kooti eno nti
he did a scene reconstruction
nti yagenda mu maaso n'agenda neyeetooloola ebifo byonna ebyazzibwamu omusango,
where he took several photos of the body of the late Susan Magara,
we yagenda mu maaso ng'akuba ebifaananyi omubiri gw'omugenzi Susan Magara
in a place called Chitiko Birungo,
awo yasookera okukubira ebifaananyi mu kifo kiyitibwa Kitiko Birungo
in Wakiso district.
mu disitulikiti y'e Wakiso.
And he also did a scene reconstruction at the house in Konge 2,
Era n'agenda mu maaso n'akuba ebifaananyi neyeekebejja n'ennyumba eri mu Konge 2 erikuli mu Makindye,
which belonged to Dr. Katongole but rented by A8.
yali ya musawo gwe bayita Katongole naye yali epangisibwa omujulizi omuwaabi ow'omunaana gwe bayita Bukenya Ismail,
Where he found a catch envelope
we yasanga ebbaasa eya kitaka
with blood stains written on Muzamiru.
ng'eriko omusaayi era nga kuliko amannya ga Muzamiru.
PW21 was among the team that went with the suspects.
Omujulizi ow'21 ali yemu ku kibinja ekyagenda wamu n'abawabirwa
A1 and A5.
omuwabirwa asooka wamu n'omuwabirwa owokutaano asooka ye Lubega Yusuf, owokutaano ye Kyebolya Abubeka,
To the land in Buyikwe district,
ku ttaka eriri e Buyikwe mu disitulikiti y'e Buyikwe,
that they had bought with the ransom money
eriteebereza okuba nga lyagulibwa wamu n'essente ezo ze baafuna
which was got from Susan Magara's family.
ezaali zifuniddwa okuva mu famire y'omugenzi Susan Magara.
Upon reaching the landing sea near Lake Victoria,
Bwe baatuuka ku ttaka eryo eri kumpi n'ennyanja eya Lake Victoria oba gye bayita Victoria,
they had already put building materials like sand
wali bamaze okuteekawo ebyokuzimbisibwa ng'omusenyu
and was also fenced.
era lyali limaze okusibibwako.
The father said that
Era yagenda mu maaso n'agamba nti
he did a video recording on the land in Luwero,
yagenda mu maaso n'akwata akatambi ku ttaka ly'e Luweero
which was said to have been bought by A1,
erigambibwa okuba nga lyagulibwa Yusufu Lubega omuwabirwa asooka,
and that he had bought 1 acre
nti era yali aguze FM
at 13 million,
yajikuze miliyoni 13
which was paid in cash,
era yasasula mu buliwo
and that the land was to be used as burial grounds for Muslims.
nti era yalaga ekyali kigambibwa nti ettaka era ligenda kukozesebwanga eby'okuziikamu abasiraamu. Asooka Yusuf Lubega wamu ne Waswa Hussein
that signed on the sales agreement of the land
abateeka omukono ku ndagaano eyagula ettaka
in the Buyikwe district, which was about 35 acres.
erisangibwa mu disitulikiti y'e Buyikwe era ng'ettaka eryo liweza eka 35.
My lord and the accused defense, they all denied both offences where
era mugenda mu maaso n'okwewozaako mwenna mwagaana emisango egyo nemugamba nti
where everyone testified in this honorable court.
era omujulizi asooka Yusuf Lubega yagamba yawa omujulizi mu kooti eno
He was a taxi driver
nti yali muvuzi wa taxi
who would sometimes drive school children to different destinations.
nti ebiseera ebimu nga yavuganga abaana b'essomero okugenda mu bitundu ebyenjawulo.
He also stated that he had his plot
era wagamba nti wali olina poloti yo
with a 3-roomed house which UNRA compensated him with 18 million.
ng'erimu ebisenge bisatu, ennyumba ya bisenge bisatu nti era UNRA oba ekitongole ky'ebyenguudo kyali kyakuwa ensente miliyoni 11.
H1 A7 testified that they had just come from Malangala.
nti omwalirwa owokubiri Waswa Hussein wamu n'ow'omusanvu Kato Hassan Mwiro mwagamba nti mwali mwakava mu kifo ekyo ekiyitibwa Malangala.
And I just stayed with their stepmother in Kisenyi for 1 month.
nti mwali mwakabeera wamu ne muka kitammwe mu kifo ekiyitibwa Kisenyi.
And at that time of their arrest,
nti era mu kiseera bwe babakwatira
they were sent by their stepmother to go and buy foodstuffs.
nti mwali mutumiddwa muka kitammwe okugenda okugula emmere.
And on their way back home,
nti bwe mwali mukomawo nga mumuka okugula emmere
they decided to branch by Usafi Mosque for prayers.
nti ne musalawo mugende mu muzikiti gwa Usafi okusaba.
And that's where the arrest happened.
nti era eyo gye babasanga ne babakwatira eyo.
F3 stated that he was working as a welder and fabricator.
Sali Muzamiru wagamba nti wali muntu ayokya ebyuma.
And that on that fateful day,
nti era ku lunaku olwo lwennyini
he had gone to his workplace in Nansana.
wali ogenze gy'okolera ku kifo ky'e Nansana.
Then after went to town to buy more material.
nti era oluvannyuma n'ogenda mu tawuni okugula ebintu ebirala ebyokukozesa.
And on his way back to Nansana,
nti era bwe wali okomawo ng'ogenda Nansana,
a certain car intercepted their car.
nti emmotoka n'ejja n'ebeekiika mu maaso g'emmotoka yammwe.
And then he was arrested.
nti era ne bakukwata.
F4 said that she was managing the family estates.
Nakandi Hajara wagamba nti wali olabirira ebintu bya famire yammwe.
Family estates including house rentals
nga mu bino mulimu ennyumba ezipangisibwa
that were located in different places around Kampala and outside Kampala.
ezaali ziri mu bitundu ebyenjawulo mu Kampala ne wabweru wa Kampala.
She also made liquid soap,
nti era wali okola sabbuuni.
worked with a labor security company called Security Link.
nti era wali okola n'ekitongole ekyokwerinda ekiyitibwa Security Link
in Mengo
ekisangibwa e Mengo
from 2011 to 2018
nti wakola nakyo okuva mu 2000
before her arrest.
okuva mu 2011 okutuusa mu 2018 nga tebanaba kukwata.
She was also working as a live She also worked with
nga omuntu akwataganyiza office eyali e Uganda wamu ne Saudi Arabia nga zikwataganya oba ziddukanya.
A5 testified that he was working in Lufula, which is found in Kampala, Port Bell Road, and was selling cooked food, meat, and tea. And that he was arrested at a place called Saboni on his way back home. S6 stated that for him, he resided in Mengo and roasted goat's meat in Senyi. Business. And on that fateful day, he had gone to pray to Usafi Mosque. A8 said before his arrest, he had an agrochemical shopping container village around the Wino Market. And on a good sale, he earned profits of 200,000 shillings. And on a bad sale, it was below. The father stated that he had 2 cars which were being used as taxis that gave him 70,000. Moses. Informing of a new site if he didn't have any work. And when he went to the friend, he offered him tea. Before they could go to the site. While there, a vehicle came, Ipsam, where his friend went and talked to the people in it. And he thought it was the boss. Before then, he saw men coming from back and in front of the car and arrested him. In our observation, my Lord, at times being sarcastic, and concerning the business they operated and work or jobs they did, would not fund the acquisition of all the properties, all the properties that they had, and that is to sell the land in Bukekete, Ruweru, and all the vehicles they had. In regards to their witnesses, some of their testimonies we found them to be lies. This was evident when the mother of A2 and A7 denied her son's photo of the national ID.
ebifaananyi by'abaana be
displayed in court.
ebyali mu ndangamuntu zaabwe ezalagibwa mu kkooti.
Also, some contradictions were noted.
Nti era obukontani bwalabikira. Obwokukontana kwalabikira.
Some answered rudely.
Abamu we baddirangamu n'obunyiivu bungi.
And others deliberately refused to answer some questions.
Nti ate abalala ne bamutima bugenderevu ne bagaana okuddamu ebibuuzo ebyo.
In our view, my Lord,
N'olwekyo Mukama waffe,
we have found that the prosecution case overweighs the accused's defense.
tusanze nti obujulizi obwaleetebwa abawabi ba gavumenti bw'amaanyi nnyo era businga obujulizi obwaleetebwa mmwe abawabi baffe.
My Lord, the prosecution has proved all the ingredients of the two offences beyond reasonable doubt.
N'olwekyo abawabi ba gavumenti bakakasizza kkooti ne batalekaamu kamu wadde n'akamu.
Therefore, we advise this honourable court to find all the 9 accused persons guilty and convict them.
Nti omusango guno gumwabuza nti era basaba kkooti eno ekubasingize.
All the 3 assessors signed on that.
The accused persons in the murder of Susan Magara include Buvumbo Musa Abbas, Yakubu Byansi, Nakandi Hajara, Chewali Abubeka, Yusuf Lubega, Waswa Hussein, Kato Hassan Miro, and Salim Muzamin.